I'm Travis Flans with WordPress KC, and we're getting ready to start our presentation with Chris Brown from Venture Legal tonight. We're going to be talking all about creating great client agreements. If you have any questions or comments, make sure you do it on the live stream in the WordPress KC Facebook group, and we'll put that on screen and Chris will address it. So Chris, whenever you're ready, go ahead and take it away.
All right, cool. Thank you, Travis. Hello, everybody. Like Travis said, my name is Chris Brown. I am an attorney. I've done a few different events with WordCamp. I've been to your multi-day event that you've had out of Johnson County and other places. I really love your group. And so, yeah, today we're going to talk about client agreements. Do you want to throw my screen up there? There it is. Yeah. Okay, so I've got two different things. Kind of a little bit of background about me. Before I became a lawyer, I was a musician and a recording engineer. I actually went to undergrad to study that, and then I went to New York City, where I worked for a while before going to law school. Today, that was like 15 years ago, but today I work with my own law firm, Venture Legal, where I represent startups, freelancers, and small businesses. So my client base is a lot of web developers, photographers, marketing professionals, and so on. It's a lot of creative type people. And then I also run ContractCanvas.com, which is a digital contract platform for creative freelancers. And we can get into that a little bit later if you have any questions about it. Before I go too far, I have to give, of course, the legal disclaimer. Don't do anything stupid. This advice is general in nature. It's not intended for anybody in particular. It's obviously not confidential. So if you ask any questions or post anything in the chat room, then obviously that's not confidential. And then last, of course, I'm not your lawyer. Just watching this doesn't make me your lawyer. So the first topic that we're going to talk in a little bit, just kind of higher level here, which is what is a contract? And I should also pause real quick. If anybody has any questions, feel free to share them either in the chat group or straight to Travis or whatever the easiest way is. And we could take a break at any point to talk about questions. It's usually easiest just to address them right in the moment rather than waiting until the end. Hello, Sarah. I can see little pop-ups. There we go. That's coming from Facebook. That's great. Okay, so we're going to jump in. What is a contract? At the highest level, a contract just requires three things. So first, you have to have an offer. Second, you have to have an acceptance. And then third, you have to have consideration. So what that means is it's really easy to create a contract. I could say, hey, I'll build you a website if you pay me $5,000. And then you might say, okay, great, I'll pay you $5,000. Well, my offer to you was that I'll build you the website, and you accepted it by saying I agree. And the consideration, which is the something of value, are the two pieces there. So on one side, you've got me building the website. That's the work that I'm doing, the value that I'm creating. And on your side, it would be the paying me $5,000. What's interesting there is that you don't have to actually have a written agreement. That's not one of the three requirements. There are some exceptions that do require written agreements, things like wills and trusts, prenups for marriages, transferring property like a house and so on. That requires a written document. But for most of what you will all be doing, building websites, you don't actually have to have a written agreement. With that said, it's usually a really good idea to put it in writing. There's a lot of different reasons for that. Of course, I mean, you don't want to have uncertain terms with your client. If you get into an argument with your client, it's nice to have an agreement to go back to. But I'd say one of the most important reasons why you would want to put it in writing is simply so that the parties will know what is expected of one another. And by doing that, the odds of a dispute go way down because you've talked through a lot of different what-if scenarios. I can't tell you how many people come to me having a fight with their client, and a lot of it's just because they never went through the process of creating a contract. So those are the basic requirements. In terms of how do you get a client agreement, there's basically four ways you can do that. Number one, you can write your own contract. Lots of people do that. It's actually not that bad of an idea to write your own contract. A lot of people are really afraid to do that, but you really don't have to be that afraid. I mean, there's various legal things that you might miss by writing it yourself, and that's not great. But the beauty of writing it yourself is you make sure that the things that are most important to you are in the document. You can, of course, buy a template online. I actually sell templates on my website at venturelegalkc.com, where you can literally just go in there, type in your credit card number, and download a client agreement in a couple of different formats. Then there's a bunch of other websites out there. You can buy books that have templates and so on. And that's a decent option. You can also use a platform. So I don't want to promote contract canvas too much, but at the same time, it's a new platform that we've created. It's kind of like LegalZoom in a sense, and I'll talk more about it later, but you can use a platform kind of like a SaaS offering to create and sign client agreements. And then the fourth option, which I suppose is the most traditional and probably the safest option, is just to hire a lawyer. When you hire a lawyer, you're going to end up getting very customized advice, not only for the state that you're working in, but also with respect to the deal types that you work on. So if you do website development, building Wix sites is different from building WordPress sites versus a fully customized site and so on. So when you hire a lawyer, you can get ultimately a better customized contract. When you're thinking about how you want to actually create your contracts, there's basically two options. You choose a single project agreement. And so what that says is, going back to my example earlier, you might say, I'll build you a website, and the client's going to pay you $5,000. That's it. You build the website, they pay you the money, and you're done. What most people in your situation would probably prefer to do, though, is to create relationships with clients where you can get more than just that one project. So a great example for a web developer might be that your first project is to do some kind of a marketing strategy or a wireframe or something for the website. Maybe you could do branding guidelines or something. Second project might be to actually build the website. Third project could be to do ongoing maintenance for the website, maybe even producing content, ebooks or whatever. But the idea is that those are all individual projects that you're going to get, and they might all fall under the same agreement, but odds are that such a long project that you might just do those under what's called statements of work. What you could do here in those scenarios is you sign a master service agreement or an MSA, and that service agreement says you're going to work for that client, the client will pay you. And then it lays out a bunch of legal terms that we'll talk about here in just a few minutes. But what that agreement does not do is it doesn't actually spell out any specific services or any specific payment terms, because it's more of a broad agreement. Then those statements of work are what you would sign that exist underneath that MSA. So the statement of work number one could be the wireframe, marketing strategy, and so on. Statement of work number two could be the actual development of the website. And statement of work number three could be a 1-year maintenance contract where you update plugins and everything else. The beauty of that is you don't have to go through all those legal terms and negotiations when you're just doing SOWs. I mean, you still have to negotiate the price and so on, but at least all the legal stuff is done and out of the way. So it just makes it a lot easier for you to sell multiple projects to the same client. So we're going to spend most of our time here in the next, 30 minutes or so talking through these various essential client agreement terms. These are really the biggest things that you should think through in terms of what you put in your contract. There's other things you could include, but these are really the big ones. Before I move on, I'm going to check to see if there's any other questions. And I don't think so. So I'm just going to keep on moving. Oh, hi, Travis.
No questions yet.
No questions. All right.
I'm encouraging, but none yet.
Oh, that's okay. Okay, so let's jump into these essential terms. The first one is the parties. Who's in this contract? And there's mainly two places that you should put party names. First is at the top. It's usually the very first paragraph. If you use a list type format for your contract, it might just be in a list form. But the gist of it is at the top of the contract, it should clearly identify the two parties. The other place is in the signature block. So that's obviously at the bottom of the contract where you sign the contract. It's a really big deal that you get this right, because the party to the contract is the one that's going to be legally obligated to perform those the obligations in that contract. So if you sign with your own name, John Doe, for example, that means John is going to be personally liable for everything under that contract. Even if John has an LLC or a corporation or whatever set up, John will still be personally liable because he's the one who actually signed the contract. Actually, I should rephrase that. It's because his name was the one that was listed in the contract. If you have a company, which I usually recommend, and for most web developers, a basic LLC formed in Kansas or Missouri is usually a pretty simple, easy way to do it. Then you always want to make sure that your LLC is listed at the top and at the signature block. You're still going to sign your name, but it's important to have your LLC name at both the top of the contract and at the signature block. If you have a DBA, you can put your DBA in there as well, but you'll want to make sure that it's very clear that it's just a DBA and not some other type of business entity. Let's see here. Next up is going to be the services. So you're going to hear kind of a common thing here, which is to be as clear as possible. The goal of a contract is to prevent ambiguity between the parties. And so an easy example here might be, you never want to just say, I will build you a website. I have no idea what that means, right? How many pages, what's on the pages, what platform do you use, and so on. So the more detail you can provide, the better. In the context of building a website, in fact, I actually ran a website development company for a while for law firms. What we would do is we'd say you're going to get 12 pages, and we would have like a list of every page, about page, service page, contact page, and so on. We would say each page will have somewhere between 300 and 500 words. We would say that we will purchase, say, 5 or 10 stock photos to put on your website. And then we would also say what we are not doing. So, for example, purchasing plugins, ongoing maintenance, hosting fees, buying a domain, all of those things that we would exclude, we always make sure that we would include those exclusions in the contract itself so that the client is not confused later about, oh, well, I just thought you would give me a domain. The other thing that you should think through is timeframes. So if possible, provide an estimated timeframe will usually help your client out. And you can also include a provision in there that says that if your client doesn't respond to your requests for information, maybe surveys or bios or photos or whatever, that you're not necessarily liable for any delays that result. Inevitably, and I'm sure you've probably all run into this, you'll be working with your client and you'll say, well, I need your headshot in order to finish your bio page. And they haven't even scheduled the headshot to be taken. And so you don't really want to assume liability for their delays. Anyway, the gist of it is provide as much detail as you can when you're talking about what you are and are not doing. Same thing kind of for payment. You don't want to leave that open-ended. So my example earlier was, you'll pay me $5,000 if I build you a website. Well, I don't know much about how that works. Is it one $5,000 payment up front? Is it a payment at the end? Is it milestone payments like $5,000 or $1,000 every 2 weeks, or what is it? Also, are invoices required, and do you take credit card payments or check payments? Be as clear as you can. What I normally say is the developer or the company will invoice the client, and the client will usually have either 15 or 30 days to pay the invoice. When you're signing up a client, it's usually a good idea to ask for a down payment. I think something like 50% is a pretty good milestone to ask for up front. And if you do ask for money up front, you should be clear about whether or not it's refundable. So a lot of times, like for example, when we would do it under our web development business, we would say 50% due up front, and that 50% is not refundable unless we do something wrong on our side. But if the client decided halfway through that they're not going to finish the project for some reason, we'd at least get to keep that 50%. The other thing that you want to think about is reimbursable expenses. When you're building a website, there's all kinds of things that you might have to pay for. Stock photography, videos, buying custom fonts. Maybe you're going to use some fancy plugins and so on. You just want to make sure that those are going to be clearly outlined in the contract so that you get reimbursed for them. Or if you want, sometimes people will just build those into their fee. So if they're doing a fixed fee project, maybe they say that includes 5 stock photos or whatever. Any questions on payment or services? Doesn't look like it. Okay, so let's keep going. Intellectual property is probably the most important thing from a legal perspective for freelancers, agencies that are building websites. The most important IP topic that you should consider is copyright. The other areas of IP that are relevant would be patent law, but I doubt that you're really inventing very many things. Trademark law, which protects brand names and logos and colors and so on. And then the last one is trade secrets. And so trade secrets will protect confidential information. And I'll jump back into confidential information here in a few minutes. But copyright is the one that most of you are going to be involved with. And the reason for that is that when you're building a website, almost everything you're doing will be protectable under the Copyright Act. Whether it's the code that you're writing, HTML, CSS, or whatever, whether it's website content, if you're producing content for their website, the layout and design themes that you're choosing, that's all going to be subjects that are copyrightable. So the big question that comes up is who will own that copyright? And there's really three ways that I see this usually happen. And for most of you that are working as a freelancer or are in a small agency, the default rule is that everything you create, you will own and not the client. Even if they pay you money, the Copyright Act says that the creator of a work is the owner of that work unless certain conditions are met. One of those conditions is if you're an employee, your employer owns everything that you create. But for contractors, which I'm imagining a lot of you are contractors, the contractor actually will own it unless there's something in writing transferring it to the client. You can either call it a work made for hire, or you can just do an assignment, but either way, it needs to be in writing between you and your client. So it's actually a really nice benefit to being a contractor is that you own everything. Of course, your clients typically want to own whatever you're creating for them. So here's where the three options come into play. One is that you could say that you own everything you develop. And in that case, your client usually is going to ask for some kind of a license so that they can use it. So I know that there's some web shops out there. I generally don't like this model, but I know that there's some that do it, where they build you a website. Maybe they charge you less money for this reason. And then they say that they will continue owning the website and they just give their clients a license to use it for as long as the client pays them some monthly fee. And there's usually hosting and other things going on with that too. I don't think most clients appreciate that model, but if it works and if you're able to make that into a business, then certainly you are welcome to. The other option that is way more common is that the client simply owns everything that you create under the contract. But as web developers, and especially people using WordPress, using plugins like Yoast, certainly if you're doing anything with open source code, you're probably going to run into some issues where you can't necessarily transfer ownership of everything to your clients. So that's where the third option comes in. But if you do go with that second option, and I suppose even with the last option, even though it's not noted on the slide, you should always consider whether or not you want to get rights to use your works in your portfolio. So maybe you want to have a page on your website that has some of the example sites that you've built in the past. You should make sure that your client agreement says that you have the right to do that, especially if you're giving ownership of the copyright to your client. Somebody's got a question there, and I'll come right back to that question in just a second. The last way that you could do it, which is the way that I tend to see most people doing it, is you, the creator, will continue to own the core assets. And so like you might have some website design themes that you reuse with multiple clients, or some code that you use on the backside that you use with multiple clients. But the specific works, so the actual website itself, will be owned by the client. Mainly things like copy and bios and headlines and things like that. So you're kind of dividing the works up into two. Things that you reuse repeatedly with clients, you will continue owning, and then things that are specific to the client, they will get ownership of. And when you do it in that format, and I guess you can kind of do it with all of them, but really with that last one, you should spell out that you might be using works that are subject to open source code, and or spell out whether or not you're using things like Yoast or WordPress or whatever it might be, that you cannot transfer ownership to the client because you don't have the right to do that in the first place. So let me hop over. I know I saw a question here from Andy. Let's see here. I use milestone payments with website projects. Is there a good approach for getting paid in a timely manner regardless of extended project delays by the client? That's going back to payment. Let's see here. I mean, the best way to do this is outline payment based on date. And sometimes your client may not like that, and sometimes you may not even like that. But the best way to do it is to place like estimated timeframes for when you're going to be doing the work. So going back to my easy example again, a $5,000 project, let's just say you think it's going to take you 5 weeks. I would say that your contract should just say that, $1,000 is due on every Monday or every Friday or whatever it might be. And then you would also have in that contract something that I had mentioned earlier on the services slide that says that you're not responsible for their unreasonable delay in responding to your requests. The downside is I think a lot of clients will just simply not pay you, even though they might have a legal obligation to pay you. And they might do that because they just don't feel like it, but also they might be smart enough to know that you're not likely to sue them over milestone payments. So another thing you could do, and I'll get into this in a little bit, is have a breach and cure provision, which says that if they're not paying you, that you have the right to terminate the contract. And that's probably the safest thing you could do, is to have date payments coupled with a breach and cure termination provision that I'll come back to in just a few minutes. All right, let's see here, confidentiality. So this may or may not matter to you. It depends on what kind of clients you're working with, and it might also depend on whether or not you're giving your own confidential information to your client. So the first thing to consider is whether or not the confidentiality provision should be unilateral or mutual. When it's unilateral, it's just one party agreeing to protect the other party's confidential information. Yes, this is actually whiskey in my lifted spirits cup. So anyway, if you need to protect the client's information, you could do a unilateral agreement, confidentiality provision. But if you're also giving your information to the client, then you'll want to make sure that you use a mutual confidentiality provision so that both sides will agree to protect the other party's confidential information. The other things that you should think through when you're writing this provision is, what is deemed confidential. You could take the approach of writing a big list of everything that's included, like financial plans and business plans and so on. Or you can also take another approach and just kind of use an open-ended definition, which is, information that a reasonable person would deem confidential. But you also should consider including exceptions. So this would be exceptions to that definition, such as information that is public, information that you might create on your own without using their info, and so on. But you also should consider exceptions to the obligations. So what I mean by that is confidentiality provision usually says that you're not allowed to disclose your client's confidential information to anybody else without their permission. But if you use subcontractors, or if you have employees or vendors or somebody that has to know that info in order to provide services to you, then you'll probably need an exception in there that says that you can give the confidential information to those other third parties without your client's permission, provided that you have something in writing with them that excuse me. Anyway, provided that you've got something in writing with that third party to protect that confidential information. And then the last thing on this topic is to consider how long that confidential obligation should survive for. So that could be anywhere from like 1 year to 5 years after the agreement expires. Any questions? No. Okay, so on to the next topic, which is non-solicitation. If you've got contractors or employees working for you, this is a really important provision that says that your client basically will not go around you to hire those people. So you might have like a copywriter who writes content for you for your websites that you're building. You probably don't want your client to be going straight to that copywriter and hiring them without you at least giving permission to do it. And so that's what a non-solicitation provision can do. It can say that the client will not go around you to work with any of your clients without their permission. So for the signature, Facebook user, don't have a name, says, do you include both your name and your business name, or just your business name and your signature? That's a good question, and I don't know if I have it easy to find. Oh, sorry, I was muted. So I was trying to find this quick blog post. So this is actually on my website. When you're signing a contract under your own name, that's when you would use this one at the very top here that says wrong. You can ignore the fact that it says wrong, but If you sign a contract using that format, that means that you are personally liable for the contract. You could do this one here that's better, but I would ignore that and just jump right here to best. And what you want to do is print your business name here, sign your name, print your name, and print your title. You can either use this format here or you could use this one over here. Either way, the core part of this that makes it enforceable against the company is the fact that your company name was printed up there first. You could always put your company name after your signature up here, but in that scenario, it's not very clear if it's John signing and this is just identifying who he is, or if it's actually Nuco signing the contract. So you always want to use this format here. So yes, your name does get printed and get signed, but most importantly, you've got your business name up there. Okay, now let me see if I can hop back to the presentation. There we go. All right, thank you for that question. Feel free to chime in. And actually, I've got a couple more in there. So Carissa, hello Carissa. I bet you like this purple background. What happens if you sign an NDA that explicitly states no contact with the, I got lost, with the subclient, but that subclient adds you on LinkedIn because they saw I had looked at the profile? I'm not following exactly, but I don't necessarily think that that's bad to get connected on LinkedIn. I think the only thing that would matter.
So sounds like she was contracted from somebody who was doing a project for a client, and their agreement said that they can't have contact with that person directly, but the other person reached out to them, right?
Yeah, that sounds like that might be what she's saying. I mean, I think it depends on the actual language of the NDA itself, but I don't necessarily think that I would call that a breach of the non-disclosure agreement. I mean, it really depends on the language in the agreement, but to me, unless you're actually exchanging confidential information, I don't think it's a big deal. Sometimes you'll see an NDA that says that the actual relationship itself, like the existence of the relationship, is confidential, and maybe that could get you in trouble, but I don't see that really arising to be an issue. Let's see here. So she says, additionally, what if out of pure random... Oh, I see what you're saying. She said that she didn't accept the request. She just doesn't want to get in trouble. I mean, I can't say for sure that it would be okay, but I just can't fathom how that would really become an issue if you did. Okay, so then let me jump down real quick. Let's see here. Oh, now I'm seeing the additional comments down here. I was designing the link in here. Yeah, so anyway, Chris, I think that you'd probably be okay in that scenario. Okay, back to the presentation. Okay, great. Okay, so essential contract terms. Now we're talking about term and termination. So one thing that you should think through is whether your agreement needs a specific term. If you're just doing a basic website development project that might take 5 or 6 weeks, you don't necessarily have to have what's called a term, which is the length of the contract. Conversely, if you're doing like a maintenance agreement where you're going to update plugins and so on their website on a monthly basis, you probably do want some kind of a term in there, whether it's 6 months, 1 year, 5 years, whatever it might be. But it should be very clear how long the agreement is. You could always do perpetual agreements, in which case the term of the agreement just continues on forever. But I generally don't like perpetual agreements. I feel like they can get you and your client into a weird spot. But in some ways, it's nice because you can lock a client in forever and then just have some kind of a termination right where either side can terminate with 30 or 60 days notice. And that actually gets right into the next 2 bullet points. So first one being, can the client terminate early? And if so, how? And can you terminate early? And if so, how? Clients often want the right to terminate your contract. And if you're just doing like a 2 or 3 week deal, it's probably not a very big issue if they get the right to terminate. However, if you're signing up for, say, 20 hours a week for 6 months, you probably don't want your client terminating after the first month and leaving you hanging, because you might then all of a sudden not have enough work to fill your schedule. So for that reason, I like to have some kind of a early termination notice provision that says that they have to give you something like 30 days notice before they terminate. Or if it's a really long contract, you might ask for 60 days. And then conversely, you'd want to think through whether or not you have that same right. Their freelancers or their agencies to be able to terminate early. So I don't see that as common, but sometimes I do. And certainly if it's a perpetual agreement or a very long-term agreement, like 3 or 5 years, I think it's reasonable for you to ask for some kind of a right to terminate early on your own behalf. But then you get into this last option, which I think should be in most contracts, certainly most development contracts, which is breach and cure. And somebody earlier had a question that was related to this. Andy did. So Andy was asking about what happens if a client's not paying the milestone payments. And so this is a great thing to include in your contract to protect you in that scenario. So what breach and cure says is if you or the client are in breach of the agreement, that the non-breaching party can provide notice and say, hey, you've screwed up. You've breached the agreement. I demand that you fix your breach, which is what cure means. I demand that you cure your breach within 10 days or 15 days or whatever the appropriate time frame is for you. And if you don't cure the breach, then I'm going to terminate the contract. So going back to Andy's example, if he's getting paid, $1,000 every Monday, and the client doesn't pay it for a week or two, he could send them a notice and say, I demand payment, that you catch up in full within 10 days. And if you don't, then I'm going to cancel the contract and walk away. And so breach and cure is really helpful. For your client, what that means mainly is if you are just simply not performing, you're not making your deliverables or whatever it might be, then your client can give you some notice and you have that same amount of time to fix it before they can terminate. Okay, then there's a whole bunch of extra stuff that I'm not necessarily going to dive into right now. But this is all in my ebook that I'll reference here in a few minutes. There's a bunch of just miscellaneous legal terms that you'll see at the bottom of a contract. You really should not ignore these. They're extremely important. They're also extremely boring to read usually. But one little change in any one of these can have implications across your entire contract. So you really want to make sure that you read all of these. These are things like assignment, whether or not the parties can assign the contract, amendment, like whether or not you can amend the contract without the other side approving it, and so on. Before I move on, any other questions? I don't think so. Okay. So next up is how to review a contract. I'll hop forward just really quickly. I just want to highlight. I've got this ebook on my Contract Canvas website, contractcanvas.com. And in that ebook, it pretty much talks about all these various issues that we're talking about here. There's also a 25-point contract review checklist that you might want to check out. But at a high level, here's generally what I tell people. First thing is, make sure you have a good understanding of what you want out of the contract. If you're going to be building that website for the client, make sure that you understand that you need to get paid for your services and expenses and so on. Then you always want to review the service provisions. And actually, I should back up. What I mean by this is if your client gives you a contract to review, because some clients will. If you're working with somebody like Cerner, they're going to give you their contract. They're not likely to sign your contract. So anyway, first figure out what it is that you expect, and then review the services, payment, and IP provisions in particular. Those are usually the first three places that I look to. And then I read the rest of the contract. And like I said earlier, it's really important that you read every single section, because you could have one little provision somewhere that's out of place that could have some seriously bad implications on you, and it's just buried somewhere and you didn't see it. You always need to look at the termination rights to make sure that you can understand how you get out of the deal if things are just not going right. But then also, how can the client get out? Because, if you're doing a 6-week project for somebody, you just want to make sure that you know what your risk is in terms of if they can cancel early. And then you need to look at, is anything missing? And that's the area that I think people will screw up on the most, is they review the contract, they say, oh, it looks great, but they didn't step back to think what might be missing from the contract. And if there is something missing, then it's important that you add it back in. And then last, does anything need to be changed? If you see little things here and there, it may not be worth raising every single issue you see. But certainly the big issues, are you going to get reimbursed? Who's going to own the IP? If there's something in there, then you definitely should feel free to make some changes to it. So again, you can download that ebook at contractcanvas.com. And next I'm going to talk about, how do you negotiate? So first up, I always tell people to ask questions. I think one of the biggest issues that people run into is they see something in a contract with a client and they just don't understand it. They think it's weird. They don't get why the client would be asking for the freelancer to be doing whatever that thing might be. But a lot of times when you just ask a question, which might be uncomfortable to ask, but you quickly realize that they made a mistake and the contract provision wasn't supposed to be there to begin with, or maybe they've got some behind the scenes reason that they've included that provision, and it might actually make a lot of sense. But the point is, ask questions and have a dialogue with your client. Don't just make assumptions. Next up is be smart about how you make your change requests. Whenever you can, you should try to keep the language that they proposed and just make small little changes to it rather than deleting entire paragraphs and rewriting them, because that just tends to upset the other side. With that said, if the provision is just really bad, you might have to delete it entirely and replace it. But whenever possible, if you can just make minor changes to their language, it's usually a better way to do it. And last, be assertive when necessary. So, you have to stand up for yourself, and you cannot let people boss you around when it comes to signing a contract. But you also have to know your bargaining power. So I used that example with Cerner earlier, and this applies to any company. They're going to have a lot of bargaining power. They can pretty much hire any contractor that they want to work with, and if you don't like their legal terms, there's a very good chance they just simply won't work with you. Whereas if you're working with a mom and pop store down the street, they're probably going to be way more willing to make changes to their contract if they even have a contract. But the point is, stand up for yourself and try not to get walked over unless you're, just forced to accept whatever it is that they present to you. And I think that might be it. So yeah, I've got my email address here, and I've got two different websites. VentureLegalKC.com is my law firm. ContractCanvas.com is my side business, if you will. And I'll briefly explain what that is. So for creative professionals, which pretty much all of you are, you can go to ContractCanvas.com and create an account, and you can create what we call contracts designed for humans and not lawyers. So the contracts have icons and plain English and a summary page that you and your client can review to make sure that you understand those key points. And then underneath that summary page is a full legal agreement, so that if you and your client ever get into a dispute, you've got a full contract there that you can take to court if necessary. And then both of you and your client can sign the contract right through our platform. We send out emails with a final copy to both sides, and we also save it to your dashboard. And earlier today, we created a referral code just for WordPress KC. So if you were to type in WPKC when you're signing up for your account, you can get a free month of Contract Canvas in addition to the first contract that we give out for free to everybody. So I'll leave that page up. But I'm happy to answer any questions from anybody, including Travis or anybody else out there.
Hopefully we have some questions come through. I know there's a little lag between here and the live stream, so thank you so much, Chris, for presenting. And I'll just ramble here a little bit. Hopefully we get some questions because I know how that is. Soon as the live stream goes off, people are going to ask questions, right? But yeah, thank you for presenting, and thank you for reaching out and offering to give this presentation. Whenever you present to the WordPress KC community and WordCamp Kansas City, it's always, your presentations are obviously always, I don't know if it's obvious to you, but it's obvious to us as the organizers. They're the most popular. People are always like, when is he going to come back again? So thank you so much for your time, and thank you for that free month. And personally, I want to apologize that I didn't get in on your beta. I realized that you had asked me to look at it, and I apologize. It got buried in my emails, and then when you reached out to me, I was like, crap, I never got back to him. So I apologize for that.
Yeah, no worries at all. No worries. Yeah, and thank you to everybody for tuning in tonight. Andy and Jeff, Pam, Carissa, everybody, thank you. So I should be at your next conference whenever that gets rescheduled. I hope I can make it. So
yeah, hopefully we're not looking at December and doing it all virtual. Although
you know what, you'll be a pro at that by then. So
I know we're going to get lots of practice. We just need people who are as good producers on this end as I am. Just kidding. So thank you very much, Chris. And for all the rest of the WordPress KC community, this presentation will be uploaded to YouTube. We've got our next couple on the calendar. We're still looking for some speakers as well, but we're going to be virtual live streaming until further notice because we want to make sure everybody's safe and happy out there. So thank you all very much. Thank you, Chris.